All right. Good evening, everybody. Thank you so much for joining me this evening. My name is Samuel Berkson. I'm an associate with Jacobowitz and Gubitz. We are a full-service law firm in the Hudson Valley. We've been serving the community for over 50 years. This webinar tonight is the Landlord and Tenant Proceedings in New York State and the impact of COVID-19. I think this might be the fourth or fifth webinar that I've done since March. It feels like a lifetime ago. There's been a lot that has gone on. A lot of changes have occurred in regards to landlord-tenant relationships, evictions since March when the pandemic struck. And so I'm definitely going to, go through that and go through the impacts that the pandemic has had on eviction proceedings in New York. I'm also going to generally address eviction proceedings in New York, the rules that must be followed in those summary proceedings. And so, like I said, I'm an associate attorney with Jacobowitz and Gubitz. We are a full-service law firm. We operate out of Walden and Monticello. We operate in over 30 areas of law, bankruptcy, business, estate planning, environmental, equine, matrimonial, municipal, personal injury, real estate, property tax. Really, if there's any legal dispute, legal issue that you have, we are a full-service law firm, and we'd be happy to take on any issue you have, not just in real estate or landlord-tenant issues, but in any legal issue. We would be fully capable of handling it. We do meetings via Skype, Zoom, and FaceTime. And I personally, I am an associate and I operate in the areas of real estate, municipal law, land use, and landlord-tenant law. And so let's get started. Just jumping right into summary proceedings. Evictions are summary proceedings in the state of New York. A summary proceeding is an expedited process through which a landlord may evict a tenant. These are justice court proceedings that take place before a local judge in a town or a village court. So it's a small courtroom, your local court, usually in your town hall or your village hall. And that's usually where the court will be. It's going to be in an intimate setting. And so summary proceedings, being a statutory creation and not a common law right, must comply precisely with the statutory requirements. Otherwise, a dismissal of the proceedings on jurisdictional grounds might result. You have to follow the rules, is essentially what that quote says. In order to get the result, as a landlord, you need to follow the rules to properly evict the tenant. You need to. It's a requirement. If you stray from the rules just slightly, then the judge will have to dismiss your case. So you have to be very particular as a landlord in following the required procedure. And evictions in New York are extremely complex. So landlords, they need to navigate an increasingly complex web of rules and regulations surrounding landlord-tenant proceedings in New York. Otherwise, like I said, the cases will be dismissed. Landlord-tenant relationship and evictions in New York are generally governed by Real Property Law Article 7 and Real Property Actions and Proceedings Law Article 7. And so you need to follow the rules. Where do you find the rules? That's where you find the rules. RPL Article 7 and RPAPL Article 7. And so you have to follow the rules. That's extremely significant. And so what are the rules? How does someone entitled to possession bring a summary proceeding? So what persons may bring a summary proceeding? Of course, a landlord who has signed a lease as the landlord can bring a summary proceeding. A purchaser at a foreclosure sale, a lessee who's entitled to possession of the property, and generally any person lawfully entitled to possession of that unit can bring an eviction proceeding. So if you're entitled to the premises, you can bring that eviction proceeding. If you're subletting, you can also bring an eviction proceeding against the subletter as a tenant. And so at a minimum, the following papers will be needed to be served with the court and then to be served by the landlord on the tenant and then filed with the court. And so what you're definitely going to need is your predicate notice, your preliminary notice. It's either going to be the notice of termination or a notice of non-payment, depending on whether you're doing a holdover or you're in a non-payment proceeding. And so if you're in a holdover, you need a notice of termination. If you're doing a non-payment, you need a notice of non-payment. And I'll get a little bit more in depth on those two different types of eviction proceedings later on. What else are you going to need? You're also going to need a notice of petition and a petition. Those are going to get served together on the tenant. The notice of petition is going to tell the tenant when and where they have to appear in court. The petition will lay out the facts of the action. It's essentially, that's the complaint that the landlord is filing, which lays out why they are justified in bringing the action to evict this tenant. So that's the papers that a landlord is required to have filed and served to proceed with their action. Now, what are the grounds for an eviction, right? Who can you evict? When can you evict them, and why? Okay? So the grounds for an eviction, we'll start, who can be evicted? A tenant shall include an occupant of one or more rooms in a rooming house, or a resident, not including a transient occupant, of one or more rooms in a hotel who has been in possession for 30 consecutive days or longer. No tenant or lawful occupant of a dwelling or housing accommodation shall be removed from possession except in a special proceeding. So 30 days is very significant. If someone stays in the premises for 30 days, they are going to get the rights of a tenant. Even if they're squatting, even if they're illegally in the premises, if they've been there for 30 days, they're entitled to the rights of a tenant, and they will need to be evicted to be removed. So that's an important threshold that a tenant, if they're, if a guest or someone has been squatting or someone's been trespassing and they've stayed for 30 days, they have rights. If they stay for less than 30 days, they're going to be technically a squatter. I'll quickly address that later on. But 30 days, you gain the rights as a tenant. Very significant to know that. And like I mentioned with the notices, we are going to go more in depth on non-payment proceedings, which are self-explanatory. That's when the tenant hasn't paid their rent. Holdover proceedings, which is when the tenant stays past the term, the end date of the lease, or if they're staying without a lease against the landlord's will. And then there are certain grounds where no landlord-tenant relationship exists. So I'll go into those more in depth. But first, I would like to address the impact of the COVID-19 pandemic on landlord-tenant proceedings in New York State. I think this is one of the most interested topics out there right now. As the courts reopen, which they are doing, the courts are reopening now for hearing eviction cases. I know that there are a lot of landlords and tenants out there who are very interested in the impact of the pandemic, all the executive orders, the memorandums, and what the current status is for landlords and tenants. And so I'm going to go over that very quickly, and I'm going to address the most important points that need to be noted. And so back on March 15th, way back in March, the Unified Court System for the state of New York issued a memorandum on March 15th. That memorandum said that next day, on March 16th, all eviction proceedings and pending eviction orders shall be suspended statewide until further notice. So back in March, the courts shut down, evictions shut down, executing warrants shut down, and that was all initiated by the March 15th memorandum from the Unified Court System. Now, 3 weeks ago, on October 9th, the Unified Court System, they issued an updated memorandum that effective October 12th, all proceedings may resume. All residential eviction proceedings may resume with certain caveats. First, these actions will be subject to local court circumstances. And so say that local court is opening up slower than other local courts. They only are doing certain court dates. They're restricting who can appear, how many people can appear. They're allowed to do that. And you're going to be subject to the new procedures that are being followed by that local court. So you need to keep that in mind. Also, commencement papers now. So if you're a landlord and you're commencing an eviction action against the tenant, you're going to need to include a specific notice that the tenant might be eligible for an extension of time based on the different legislation, executive orders, and memorandums that have been passed. And so that notice can be found with the October 9th memo, and that notice is going to be required to be included when you serve the tenant with the petition and the notice of petition. Another caveat that's important now is that all matters commenced prior to March 17th will require a court conference, no matter where that case was. So if you had an eviction matter prior to March 17th, the judge already maybe signed a warrant of eviction, an execution, to execute an eviction warrant, you probably will still need to go back into court. That's the nature of the memorandum that was issued on October 9th. And I personally have been called back into court on issues where I've had a signed warrant of execution, warrant of eviction. I've had to go back into court to conference the case. And then lastly, execution of warrants remains prohibited until January 1st, 2021. So even though eviction matters are allowed to resume in the justice courts, if you get a judgment and you get a signed warrant sometime in the next couple of weeks, sometime in November or December, that warrant cannot be executed by the sheriff until January 1st, 2021. And that's as per Executive Order 202.66. So that date could potentially get pushed back. Right now, it seems that that date is January 1st, 2021. But, there's been so many executive orders passed, I don't know if it's going to get pushed out more. There's a lot of, circumstances that might factor into that decision. And so keep in mind that might get pushed out farther, even though eviction matters have been allowed to proceed going forward. And so I just recently mentioned Executive Order 202.66. Very, very quickly, I think there are some important dates in this timeline here in terms of the impact that COVID has had and the executive orders and some legislation that's been passed in New York. And so going back to March 20th, the governor issued Executive Order 202.8. That stopped eviction proceedings. That was a couple of days after the memorandum from the Office of Court Administration, but that was the governor's office on his own volition halting eviction proceedings. Now in June, the New York State Legislature passed and the governor signed the Tenant Safe Harbor Act, which protections for residential tenants superseded prior directives. And so what that did is that basically took the governance of evictions, all these memorandums, all these new rules, and it said that everything that the governor had stated in the prior executive orders now is not going to be the primary rules. It's going to be the Tenant Safe Harbor Act and the Office of Court Administration memorandums. And so what the Tenant Safe Harbor Act did was that held off the execution of eviction warrants, and it did establish some certain protections for tenants in terms of their ability to ask for an adjournment due to a COVID hardship. And so what's important to note, however, is that it's now the Office of Court Administration who is controlling when the courts would open back up. And they have, like I said in the previous slide, the courts have opened back up as per the Office of Court Administration, even though we haven't had an executive order that says that the courts have opened back up. The memos from the Office of Court Administration have effectively done that. Now, on September 28th, Executive Order 202.66 did extend the prohibition of the enforcement of eviction warrants through January 1st, 2020. Right now, that's the only thing that the executive orders are really addressing going forward. It's whether or not they're going to push that date out, and you just need to, keep in mind if you're a landlord or a tenant that date might get pushed out farther. And then on October 9th, 2020, I just stated again that the Office of Court Administration issued its memorandum that eviction proceedings may resume. That's what I addressed in the previous slide. And so just to bring it all together, right now, the Office of Court Administration memorandums say that evictions can proceed with certain caveats. The executive order 202.6 says, 202.66 says that if you get it as a landlord, if you get an eviction warrant, that can't be executed until January 1st. So that's where we stand right now in terms of how landlord tenant summary proceedings are allowed to go forward. And so I do want to mention a few other important points. The CDC, which is a federal agency, they issued a nationwide moratorium on evictions through December 31st, 2020. It covers non-payments. It does not cover holdovers or breach of a lease. The order provides a specific defense for covered persons in landlord tenant proceedings. The order will not stop the landlord from initiating that proceeding. And for a tenant to take advantage of this defense, they will need to sign off on a written declaration attesting under penalty of perjury to several important facts. And so what's a covered person? What are those important facts? It's very specific in terms of how much income, an individual or a family has made, how the hardship has affected them, have they attempted to make partial payments, things like that are what category or what are the determining factors whether or not you're a covered person under the CDC moratorium. And so if a landlord is initiating a eviction action against the tenant, this is an option that the tenant, if it's a non-payment, if they can prove to be a covered person, they can raise this as an affirmative defense by filling out the affirmation. And it's provided, I believe, with the CDC announcement of this moratorium. So if you look online, you should be able to find that paperwork. And so I definitely just wanted to make that clear. It's not something that happened in the state of New York. Again, this is a federal moratorium, but it does provide extra coverage to tenants in New York who might be interested in using that as a potential defense. And then I'd also like to address something early on. I believe it was Executive Order 202.28, but it doesn't really matter. One of the executive orders early on, it required that tenants facing hardship may elect to have any security deposit held by a landlord applied toward overdue rental payments. If they do so elect to apply that security deposit, the following conditions will apply. The agreement must be in writing. The tenant must replenish the deposit at a rate of 1/12 the amount used per month. The agreement must cover the entire amount. Otherwise, the remaining amount is considered waived by the landlord, and the repayment shall not become due until 90 days after the security deposit is used for rent. Pretty straightforward. The tenant is now entitled to, by executive order, use its security deposit, and the landlord cannot refuse to apply that to rent. Now, this obviously might arise, might create problems if there's significant damage to the property that the landlord would have used the security deposit to otherwise cover. But this is the executive order. A landlord cannot refuse to apply the security deposit to rent. And so just to wrap up, my quick summary on the impact of COVID-19 on landlord tenant proceedings. Really, what can landlords and tenants do during these times? I think it's important. At this point now, it's been 7 or 8 months since the pandemic really started to take hold. And I've advised all of my clients, landlords and tenants, to talk to each other, because there's always an opportunity to talk to each other as human beings and try and find some middle ground. And so that's always my first advice. Sometimes that doesn't work out. Sometimes there's going to be a legal dispute, but I would advise if there's any way you can talk to your tenant and landlord, there might be some circumstances you weren't aware of, that could only be helpful. Landlords, they should reach out to their tenants, like I said, to inquire about their situation, if they're late on payments or if they might anticipate that their tenant might be late on payments, see what the situation is. And then that might allow you to work out some sort of deal or an arrangement. And then for landlords, they, throughout this entire period since March, there's been nothing preventing landlords from sending out the required predicate notices. and having their papers filed, prepared for court, prepared for filing. So if you're a landlord, there's no way to settle a dispute with the tenant. I certainly would advise you to get the notices out and get the ball rolling, unless there's some reason you think that's, that would cause an issue. Legally, you are entitled to, and you should proceed with that to make sure you get a head start once you can get back into court, which now we can. And then also tenants, they need to be aware, as any tenants watching, you need to be aware that none of these rules, federal, state, or local, have waived any requirements that you need to pay your rent that's owed. Living in the premises, you do owe use and occupancy to the landlord. Nothing is going to change that. Use and occupancy is a legal term for rent that's owed. And all tenants need to realize that this is not waived. And so if you haven't made payments, you do owe those payments to your landlord. That's not something that's just disappeared. And so that's, to summarize, that's really the impact, that COVID has had. I've gone over the executive orders. I've gone over the memorandums from the Office of Court Administration, the CDC Moratorium. And so I think these are all very important points. And those are really the main issues that have arisen and have impacted summary proceedings for evictions in the past since March. And so now I'm going to move on. I'm going to very, very quickly dive into non-payment proceedings, holdover proceedings, and other eviction proceedings in New York. Just very quickly, I'm going to summarize the notice requirements and what's needed to bring those actions successfully. So I'm just going to go very quickly through these as we go. So let's get started with non-payment proceedings, right? A non-payment proceeding is a summary proceeding that may be initiated by a landlord against a tenant who does not pay the agreed upon rent. Very straightforward. There are two predicate notices that are required. First, if within 5 days after the payment is due, that tenant has not made that payment, you as the landlord's required to send a 5-day notice to that tenant. That notice is required to say that it's been 5 days, I have not received your rental payment, and it's just to put them on, it's just a predicate notice that you have not received the payment and the payment is due. If that 5-day notice is not responded to with payment, the landlord then must send out the 14-day notice. The 14-day notice of non-payment puts that tenant on notice that if they do not make the payment within 14 days, that landlord will bring an eviction proceeding against the tenant. And so those are the two notices that are needed. First, it's a 5-day notice, then it's a 14-day notice, and then you can proceed with bringing your action. Now, it's important to note that in a non-payment proceeding, it can be cured at any time by the tenant up until the date of eviction. So you could take the tenant to court, they owe you money, you get a judgment, the judge signs an eviction, 2 weeks pass by, the sheriff has not kicked them out yet, the tenant comes to you, hands you a lump sum of money to make all the payments that are due, that action gets dismissed, the warrant of eviction needs to be revoked from the sheriff, and that person is entitled to then remain in that property until either they hold over, they leave, or if they don't pay again. And that's an important factor in non-payment proceedings. So all landlords need to keep that in mind. If it's a particular tenant that they might not want, regardless of whether or not they made payments for whatever reason, then they might want to reconsider whether this is the avenue that they want to go down. And for tenants, be mindful that a landlord needs to comply with these very specific notice requirements. The other main form of eviction proceedings in New York are holdover proceedings. These are initiated against a tenant who remains in possession of the premises after the expiration of the lease. The notice requirements for a holdover depend on how long the tenant has been in the premises or how long the lease term is. And so if the tenant has only been in the premises for less than a year and the lease term is for less than a year, only a 30-day notice is required. If the tenant has been in the premises for over 1 year, but less than 1 year, and the same goes for the lease, if the lease term is over 1 year and less than 2 years, a 60-day notice will be required. If the tenant has been in the premises for over 2 years, or the lease term is over 2 years, for a period that's over 2 years, a 90-day notice will be required. So these are significant notice periods. You need to make sure you comply. Say you send a 30-day notice when you needed to send a 90-day notice. If you get into court, the judge will throw out your case for not having the proper notice. So you need to be very precise as a landlord in sending out the required notice. And as a tenant, you need to be very observant, because if the landlord has not complied, you do have a defense to a holdover proceeding. And then there's also very specific filing and serving requirements for holdover proceedings, where the petition needs to be served and filed between the 10th and 17th day before a court appearance. And so I think it's easiest to map it out and think of it on a calendar. If a court appearance is set for, let's say, November 17th, you have a court appearance. The petition needs to be filed on the respondent, served on the tenant, and filed with the court between the 1st and the 7th of that month, okay? Because that's between the 10th and the 17th day before the court appearance. Very specific. You have to be very particular as a landlord and a tenant in looking at the notice when it was filed and served. And then there are also certain situations where no landlord-tenant relationship would exist. This only requires a 10-day notice to quit before you can file your summary proceeding papers, file your petition, and get the tenant into court. And the most typical grounds here are for squatters. I mean, squatters, I think most people have a general idea of what a squatter is. It's someone who, without being invited, stays in a premises and remains there. And if you have a squatter, they haven't been there for 30 days. Remember what I said about 30 days? If you stay somewhere for 30 days, you gain the rights as a tenant. If that person, that individual, hasn't been there for 30 days, you can send them the 10-day notice to quit as a squatter, and then you can bring an action against them. 10-day notice to quit is also applicable for a holdover post a foreclosure sale. So if you buy a property at a foreclosure auction and someone remains in the property, you only need to send them a 10-day notice to quit. And then same thing for a licensee whose license might have expired or been revoked. Very significant, very important to understand that a 10-day notice to quit is all that's required under these situations. Moving on now very quick. How does a tenant then respond to a summary proceeding against them? I've explained all the requirements that landlords have in initiating a summary proceeding. But if you're a tenant, what papers will you need to file? Now, the tenant is allowed, but does not need to file an answer. The tenant will need to appear at the courthouse on the date and at the time indicated on the notice of petition. And this way they can orally answer the petition, but they don't have to serve an answer in writing. As long as the tenant appears, they can provide a defense and answer that petition. Now, what are the most common successful defenses that a tenant might raise to an eviction proceeding? The first most common, I had mentioned it before, is that a tenant can make the payment in a non-payment proceeding. If a tenant gives that landlord the amount owed for rent, then that dismisses the entire non-payment proceeding, and that tenant can remain in the property as long as they continue to pay rent or otherwise don't cause a reason to get evicted or leave voluntarily. Also, if the landlord failed to follow the notice requirements for a holdover or a non-payment proceeding, that's a defense. If the respondent tenant raises that as a defense in justice court, the judge has no choice. If the landlord didn't follow the notice requirements, the judge has no choice. He has to throw out the case. You have to start over if you're a landlord. And then also, if the landlord might have breached the warrant of habitability, creating potentially a unsuitable living space for the tenant, that's a defense that the tenant can raise, where if they can prove that the judge cannot evict the tenant until that issue has been cured, or just, so long as that unlivable circumstance remains. And so that's another potential defense for a tenant. I'm almost done. Before I wrap everything up, there's also some very significant changes in landlord tenant proceedings in the laws that were enacted in July of 2019. The Housing Stability and Tenant Protection Act of 2019 was passed in the summer of 2019. And there were some very significant changes, and I want to quickly address those. The first, a 14-day adjournment is required if the tenant requested at the initial hearing. And so as a landlord, you're going to serve the tenant with this petition and a notice of petition. That'll set the court date for an initial hearing. If the tenant appears at that hearing and requests a 14-day adjournment, the court has to grant at least a 14-day adjournment. And so it's very common that tenants do take advantage of this provision. They will often ask for a 14-day adjournment, and there's no choice for anyone, the landlord, the court, or the judge. The court has to adjourn the action if requested. Another important change in the summer of 2019 was that only fees for use and occupancy can be recovered in a summary proceeding to evict a tenant. And whether it's non-payment or if it's a holdover, you can only ask for the rent that's owed. You can't ask for other fees like attorney's fees, fees for damages, fees for late fees, other items like that. Those would need to be recovered in a separate proceeding, in a separate money action against that tenant. The only monies that you can ask the court to grant you relief for in a summary proceeding for an eviction, like I said, is for the rent. That's it. Another important provision, warrants may not be served for at least 14 days after the order is served. So if you go to court, you win in court, the judge signs off on an order of eviction, the sheriff gets it that day, the sheriff has to wait 14 days before they can evict that individual tenant. And then lastly, the court does have, this is not the last, there are very many provisions that were included in the Housing Stability and Tenant Protection Act of 2019, but these to me are some of the most significant ones. One more is that just the court has discretion. The court may issue a 1-year stay of any warrant of eviction within their own discretion, depending on the circumstances of the tenant. I've never seen the court do this, but it is something they're allowed to do. And it's something that tenants, landlords should be aware of. But it is, in reality, in the year and a half since the law has passed, I've never seen a judge in any sense, and I've been in court dozens of times getting eviction warrants signed, I've never seen a judge issue a stay at all unless it's stipulated, and certainly not for a year. And so those are some of the more important changes to the Housing Stability and Tenant Protection Act brought about back last year. And then one thing just to keep in mind, if you are out there doing your own research on the laws in New York, some of them might have been, some things that might be published online might be prior to the passing of the Housing Stability and Tenant Protection Act. And so there's a good chance that you might be getting wrong information. And so just keep that in mind. If you're looking online and there's something that doesn't comport with what I told you or something, you're probably getting wrong information. I'm certainly giving you all the right information right now. And that's really it. I appreciate everybody for joining us. Please be aware, for everyone that's stuck with me and has been joining me for this webinar, you're all entitled to a free 15-minute consultation. Just give a call to the firm at any point. All you have to do is call, ask for me, say it's in relation to the webinar, and I'd be more than happy to talk to you and we can go over what your issues are. Like I said, just call. It's a 15-minute consultation, and anyone who has watched the webinar, you are entitled to it. So please reach out. You have my information right here. You could see scb@jacobowitz.com. So, you can reach out, and I will take some questions if anyone has any questions very quickly. I appreciate everybody for sticking with me. I know it's a late rainy day. It's getting dark up here in New York, but I appreciate everybody, and this might be the the last, we might not be doing another one for a couple of months, just because it looks like now that the courts have opened, that's, likely what it's gonna look like. You're welcome, to anyone. I appreciate any thanks, but if anyone has questions, I'll sit tight for another minute or two, very quickly. If anyone wants to quickly ask me any questions, otherwise, that's really it. And I wish everybody the best. Let me see. I got one here. Do landlords have to give a rent reduction if something breaks and needs repairs? No, landlords do not need to give a rent reduction if something breaks and needs repairs under normal circumstances. There might be certain provisions for affordable housing units, and that's something you'd want to touch base with me if that's the case. But no, I mean, the landlord will need to make repairs and keep the premises habitable, but they wouldn't need to do a rent reduction unless it's not possible to do that. So, touch base with me if it's a specific situation. How do we print these sheets, Joe? Reach out to the firm, shoot me an email, and we will see if we can get you the materials. All right. All right. So everyone, thank you so much again. I'm going to sign off, and I hope to talk to all of you soon. Have a wonderful evening. Stay safe. Have a good Halloween. I hope everyone votes. I got one more chat right here. The tenants need to prove they were impacted. They do. They do. If tenant is going to claim that they were impacted by COVID-19, they will need to prove that they were impacted. The courts have been very lenient, though. I mean, I haven't seen a court really give a tenant a hard time since the courts have reopened. I would anticipate that courts would be lenient if anyone says they have had a hardship. So that's it. Thank you, everybody. Have a wonderful night.